I have a little bit of a cold, so normally I can project and be really loud, but today my voice isn't as strong as it normally is. My name is Elizabeth Kronk Warner. It's a pleasure to be here with you today. I'm the Associate Dean over at the Law School and also a Professor of Law. And I'm here to talk to you about, I think, a challenge in Indian country that will interest you. And at the end, we can, if you are interested, we can talk a little bit about how you can participate and how you can help address this issue. So I was asked to come and talk about tribal, state, federal collaborations. This is an example of where those collaborations are falling apart. So where we need additional collaborations. And just as a precursor to this, we do have collaboration in Indian country. You can have memorandum of understanding and agreement between the state, the county, and the federal government. So a lot of tribes are working through those things, but this is an example of where they're not doing that. So the title of my presentation today is Raping Indian Country. It's based on an article that I co-wrote with Professor Sarah Deer, who you may know is a professor also here at KU. She's in both the Women's Studies and the School of Public Affairs and Administration. So she and I co-authored this article, and it's coming out in a Columbia Law Review sometime in a couple months. But the students tell us sometime soon. All right, so in terms of a presentation overview, first I want to talk about why we titled our article Raping Indian Country, then to talk a little bit about the policies of this administration and how they're contributing to this problem that we're going to talk about, and then how increased natural resource and energy development leads to increased vulnerability of many people within Indian country. And I'll give you two specific examples, climate refugees here in the United States, and then also camps that are termed man camps because they tend to be overwhelmingly male in character. And then we'll talk a little bit about some proposed solutions for the status quo. All right, so first of all, why did we title our paper Raping Indian Country? And the paper specifically looks at how energy and natural resource development increases vulnerability and increases the likelihood for sexual exploitation of indigenous peoples, with specific emphasis on Native women and Native children, as we see when we get later in the presentation. So looking at that connection between those two. And the reason why we use rape, and we do so knowing that people who are rape advocates oftentimes are very concerned anytime they see rape being used as a metaphor. The critique of that is that if you use rape for a metaphor, words have power, and so therefore the impact is that you are really taking away from what is a horrific event, and we don't want to undermine that by using analogies or metaphors. However, we think that the term rape is an appropriate term when we talk about this in the context of Indian country for a couple of reasons. So first, we're talking about serious harm, both harm to the earth and harm to the individual. And there is a connection there in terms of physically what happens that is very similar. So when we're talking about natural resource extraction or energy development in Indian country, we're talking about a process that is taking a physical, violent taking of resources from the earth, very similar to a rape itself. And of course, when we're talking about sexual assault or rape, we're talking about that happening to individuals as well. The other reason why we use this language of sexual violence is that for many of us in Indian country, and I don't want to perpetuate the stereotype of tribes being environmental stewards, because not all of us are tree huggers and not every tribe loves the earth. But many indigenous communities do have a tendency to talk about the earth as the feminine. We're talking about the earth as Mother Earth. And so for many of us who do have that feminine connection with the earth and with natural resources and with the environment, when we talk about this energy resource and traditional natural resource extraction, it very much is raping Mother Earth. So there is that connection on that level as well. Also, as we'll see throughout the presentation, because the increased use of these extractive industries to take resources from the earth does lead to increased sexual exploitation, there is a direct connection between natural resource extraction and energy development and actual rape, the physical act of rape of individuals, indigenous individuals living within Indian country. So we think that we recognize the critique, We don't want to be dismissive of the critique of using rape as a metaphor, but we do think that it's appropriate in this context. And if anybody wants to talk about that a little bit more after the presentation or during questions, I'm happy to engage in that dialogue. But I do want to acknowledge that we were thoughtful in our use of the term raping Indian country. All right, so I told you that this article in today's presentation looks at that connection between energy and natural resource development and what's happening to indigenous communities around the United States. So let's start off by talking a little bit about what is the federal role in energy and natural resource production in Indian country. When I use that term Indian country, it has a legal meaning. So anytime you hear somebody use the term Indian country, they're referring not only to reservations, but also to Indian allotments. For a wide variety of historical reasons, you could have an allotment that is nowhere near a reservation. So for example, the Turtle Mountain Reservation in North Dakota has allotments in Montana, hours and hours and hours away, but they still exist. And then it also includes what we call dependent Indian communities. So there are communities within the United States that have not been denominated a reservation, but they have been set aside for the use of Indians by the federal government, and so they're included. So Indian country, I use that term because it is a broader term than just saying a reservation, and so I use that deliberately. So to start off with, it's good to note that tribal sovereignty persists. So sometimes people are confused by that. So tribes, it still exists, tribal governments still exist today. They pre-existed the formation of the United States. The United States viewed them as separate sovereigns at the time of the creation of the United States. You only have to look at the Constitution to see if that is true. Tribes and Indians are only mentioned in 2 places within the Constitution. One, that the president has the right to enter into treaties with them, and secondly, that Congress has the right to regulate trade with them. Nowhere does it say that they fall under the laws or jurisdictions of the United States, and that's because the founders, if you go back and read the Federalist Papers, you would see that the founders viewed them as separate nations. That status still exists today. So the Supreme Court, since the birth of the United States to today, is regularly asked to look at some form of this question of whether tribal sovereignty still persists, and the Supreme Court has regularly affirmed that. So for example, in 1978, in Santa Clara versus Martinez, the U.S. Supreme Court said that tribes still exist, they're still sovereign, and they have the right to regulate their members in internal affairs within the reservation. And so that exists today. Every president, up until President Trump hasn't made a statement yet, but up until President Trump has also affirmed tribal sovereignty. So, and he hasn't said the opposite, so maybe he just hasn't gotten around to it yet, we'll see. But for a variety of historical reasons, the federal government plays a large role. So we have this tension anytime we talk about Indian country. There is an inherent tension. I always tell my students, you're not wrong, I'm not wrong, because we have both tribal sovereignty and we have a significant federal role. And the reason why we have a significant federal role goes all the way back to 1823, when the U.S. Supreme Court decided a case called Johnson v. McIntosh. And the issue in Johnson v. McIntosh was who owned land, because Johnson was a speculator. And at that time, a who's who of American politics were engaged in land speculation. Thomas Jefferson, George Washington, Benjamin Franklin, they were all purchasing land west of the border with the idea, knowing that the United States was eventually going to expand west and then they would resell it and make a lot of money. So Johnson represents the who's who of America in 1823. McIntosh in that case is a Scottish immigrant that the United States have specifically recruited to come to the United States, right? This is a time period where we want people to come to the United States. And so the United States reaches out and says, come here, settle our new country, and we'll give you this land. And so both Johnson and McIntosh were claiming the same land, only Johnson claimed that he bought the land from the tribe that occupied the land. McIntosh argued that he owned the land, excuse me, because the federal government gave it to him. So the court had to look at this question of, well, who actually owned the land? Was it the tribe who owned the land by virtue of ownership since time immemorial, or was it the federal government who owned the land through virtue of conquest, specifically conquering Great Britain, and then Great Britain had arguably conquered the tribe. So that was the theory. Ultimately, in that case, what the court does is the court says, well, the federal government owns the land, but the tribes have this right of beneficial use. So the tribes have the right to use the land. And that status exists today, to this day. We call that trust land. So if you've ever been in Indian country and you've heard tribes talk about their trust land, they're talking about land that the federal government holds in trust for them, but they have the beneficial use of, so they have the right to use it and enjoy it. And because by virtue of that decision and many subsequent decisions, the federal government has a really significant role in Indian country. And so when we're talking about energy development or natural resource development, because the vast majority of land in Indian country is held in trust by the federal government by virtue of that 1823 decision, that means that you have to go through the federal government in order to do energy development or natural resource development. So it means that the federal government is going to have a really big role. And I have listed for you here a couple of statutes that the federal government has passed by virtue of having that significant role that are going to impact energy and natural resource development in Indian country. So the first two, if you want to do any sort of substrate mineral development, so coal, for example, methane gas, you have to go through either the Indian Mineral Leasing Act or the Indian Mineral Development Act. If you want to engage in renewable energy development, you're likely going to fall under the Energy Policy Act or the Hearth Act. The Hearth Act is a very, very bad, it's like helping expedite something, very badly named statute that basically allows for tribes to lease their land for 25-year periods of time, which renewable energy developers want, right? They want a 25-year lease so that they can do the renewable energy development. And then also just in general, these last three, the Federal Power Act, the Public Utility Regulatory Practices Act, and General Gas Act are what we call statutes of general applicability that apply across the country regardless of whether you're in any country or not. So the big takeaway, the purpose of having those statutes up on the slide is really to drive home the point that the federal government plays this really robust role in energy and natural resource development in general, and even more so in Indian country because of the special relationship in Indian country. In addition to these statutes that are specific to energy and natural resource development, you also have statutes of general applicability like the Clean Water Act and the Clean Air Act and the Safe Drinking Water Act, which apply across the country regardless, again, of whether you're in Indian country or not. So, as a whole, the federal government plays a large role. And so that's all to kind of tee up this next slide, which talks about what the administration is currently doing. So the last slide demonstrated and shows that the federal government plays a large role, so we should care about what the federal government is doing. So now let's see what the current administration is actually doing. So I don't think it would come as any surprise that the president and his administration have been very clear that they're interested in domestic energy production. In fact, that was one of the points that he made while campaigning. That has been a key point in his administration. And Indian country is ripe for natural resource and energy development. So we have a lot of undeveloped, unused natural resources within Indian country: coal, methane gas, plutonium, platinum, uranium, you name it, we got it. And we're also a large source of renewable energy as well. So if you're coming off of the Rocky Mountains, those of you who've maybe driven to Colorado, you know this, that's within the continental United States, the windiest part of the United States is when you're coming over that ridge of the Rocky Mountains. A lot of tribes are along that ridge. And so they are in a great spot for wind production. A lot of our tribes in the Southwest are in a great spot for solar energy production. So as this quote demonstrates, we've got a lot of capacity for natural resource and energy development in Indian country. And as to further really bring home this point that the president is committed to energy development domestically, so he's sworn in on a Friday. The Tuesday after he's sworn in, you may recall that he issued 2 presidential memoranda which called for the completion of the then pending Keystone Pipeline and Dakota Access Pipeline. You may recall those 2 pipelines because there was a lot of national controversy over their completion. The Obama administration had put a moratorium on both of them. And so literally the second day in office, he goes ahead and signs a memoranda saying that he wants those to be completed. And so I think that's really indicative of his support of energy and natural resource development. What else has he done? So he's issued a couple of executive orders which are going to impact this. Executive Order 13766 calls for expediting environmental reviews. So the environmental review process under the National Environmental Policy Act, or NEPA, is a very lengthy process because you have to go through any project that might have a federal nexus and demonstrate how it's impacting the environment and demonstrate that you've considered that. Now, you don't necessarily have to pick the most environmentally friendly option, but you do have to go through this process. And so as a result, it can be a very time-consuming process. When I was in private practice, I think the shortest NEPA completion time I ever saw was 6 months. For bigger projects, you're looking at multiple years. So it is a lengthy process. But it's a lengthy process to ensure that we're thoughtful about environmental impacts. So the first executive order on that list says that we need to make that process quicker. We need to be doing development quicker, and we shouldn't be spending so much time on our environmental reviews. The second one, Executive Order 13783, is an actual testament to his desire to increase domestic energy and natural resource extraction. So if you're interested in the administration's stance on that, you have the executive order there. You may also be aware of the fact that President Trump has withdrawn the United States from the Paris Accord, so has withdrawn the United States from attempting to work towards climate change remediation and adaptation. Also, in June of 2017, President Trump actually sat down with tribal leaders and explicitly said, we need to do more energy development in your lands, and I'm going to do everything within my capacity as president to expedite that process and make sure that we're doing more energy development. Also, you may be aware, at the end of President Obama's term, he created the Bears Ears National Monument in Utah. Bears Ears is an area of profound historical significance to many tribes in the region. So for example, just last Friday I was at a conference and heard from the Navajo Nation's Attorney General, and she was speaking about how when the Navajo Nation were pushed out of their traditional territories, Bears Ears is where they went and sought protection, and so it's this tremendous archaeological site for the Navajo Nation, and that's just one nation. 12 nations have an interest in this site. So President Obama made that a national monument. Well, President Trump, as you may know, came in and said, no, we don't need this big of a territory. So the Bears Ears National Monument still exists, but he basically gutted the middle of it because that's the area with the natural resources and would allow for natural resource extraction in the middle of the Bears Ears National Monument, still preserve the outer ends, but kind of take away that middle section. Now, there's ongoing debate and litigation about whether or not he can do that. The Antiquities Act is the act that allows for presidents to put land into national monument status, and it specifically says that presidents have the authority to put land into that status. It does not speak at all to their ability to take out. So the argument is that President Trump did not have the authority to do that, given that the Antiquities Act is silent as to the ability of a president to take land out of a national monument. And the tribes are vigorously litigating that. So we're still waiting to get a ruling on that. And then also federal agencies have been very clear about their development ideals. So the Department of Interior, for example, under Secretary Zinke, has done several things to spur natural resource and energy development. So for example, the Obama administration had put a moratorium on coal mining on federal lands. And so Secretary Zinke lifted that moratorium, so we now have coal mining again on federal lands. Also, Secretary Zinke has charged everybody within the Department of Interior to look through their regulations to see where it speaks to climate change and if there's any impediment on development to revise that so climate change is no longer mentioned. So I think we can all take away from those two slides that the Trump administration is very much engaged in domestic energy and natural resource development, and then specifically has shown great interest in Indian country as a whole. So that's natural resource and energy development. What about the other side of the coin? What is this administration doing to protect Native individuals who might be particularly vulnerable to sexual assault? It's a lot less clear what the administration's stance is on protecting vulnerable Indigenous peoples. We don't have a clear indication. By way of review, the federal government, just like in natural resource and energy development, is very much involved in criminal enforcement in Indian country and has actually created a lot of problems with criminal enforcement. So a couple of reasons why. So the first is the Major Crimes Act. So anytime you commit a major crime in Indian country, so these are things like rape, then the federal government has the ability to prosecute you. Tribes also have the ability to prosecute you. But their ability to prosecute is severely hampered by the Indian Civil Rights Act, which limited tribal punishment authority to 1 year and or a $5,000 fine. So if you've committed a rape, the most a tribe, if you're found guilty, could sentence you to is 1 year and or a $5,000 fine. So 1 year and a $5,000 fine is the most that they could sentence you to. So what happens is we see that criminals specifically target Indian country. So for example, there was a rapist in Oklahoma who was specifically picking up Native victims and was driving them around before he would rape them so that they could not speak to where they were raped. And the problem is that creates a lot of problems from enforcement, because if you can't tell me where the incident happened, I don't know if the state has jurisdiction or if the tribe has jurisdiction or the federal government has jurisdiction. The other big obstacle to having the federal government involved, especially when you're talking about rape and sexual assault, is time is of the essence. Anytime you have a rape or a sexual assault, you need to get the evidence as soon as possible. The individuals who investigate that are not your local police department. It's the federal marshals. And oftentimes our federal marshals are hours and hours and hours away. So a good example of that is in Montana. If you're up on Confederate Salish and Kootenai Reservation, the closest marshals are 8 hours away. So even if, right, and this is a big even if, the marshals get the call and immediately jump in the car, you're looking at a half day to full day delay. The reality is that they're not getting the call and jumping in the car, right? The reality is that there's an even further delay. So as a result, when we're talking about the sexual assault and rape, we have a very high declination rate of the federal prosecutors, the assistant U.S. attorneys, because they're saying, well, we're not getting the evidence that we need to get. So this federal scheme is creating a lot of problems. The limitation on tribal enforcement creates a lot of problems. And the other big problem is the U.S. Supreme Court's decision in a case called United States versus, Oliphant versus the Squamish Indian Community. That was a case from 1978. And in that case, 2 non-natives committed crimes on a reservation. And sometimes the fear with tribes prosecuting non-natives is, oh, I might be prosecuted for some weird tribal crime. Or something foreign that I don't understand. Well, these guys punched a police officer and ran their car into a police officer's car. So hopefully we all know that these are not things you should be doing. This wasn't some weird tribal crime. But this is what the guys did. They punched police officers and ran their car into a police officer vehicle. And the tribe prosecuted them. And so this case went all up to the Supreme Court as to whether or not the tribe could prosecute these non-natives. And ultimately in 1978, the U.S. Supreme Court said that the tribe could not. The tribe had been implicitly divested of its ability to prosecute non-natives. So now lay this decision of Oliphant over all of the other problems I just told you about in terms of effective criminal enforcement in Indian country, and you can see why indigenous peoples are so vulnerable to start off with before we even start talking about energy and natural resource extraction. Because if I'm a rapist, and I'm thinking about, and people are very strategic, and if I'm thinking about where I want to commit my crime, I'm going to go do it in Indian country, right? Because the tribe can't prosecute me if I'm a non-native, and overwhelmingly about 85% of sexual assault and rape in Indian country are committed by non-natives. So I'm going to go target an indigenous woman in Indian country,